purposes, Paul Moite, Elisha Ongoya, Senior Counsel, Tom Acharia, Victor Soanya Ogeto, Willie Zecheza, Faith Waigua, John Jomo, and Faith Waigua is holding brief for Ochiel Dudley. Those are the counsel appearing for the first petitioner for the purposes of taking judgment this afternoon. I thank you.
May it please the court. I'm Tess Wanjiru Kimoto Makazi from Tess Kimoto and Company Advocates, Kerugoya, Kirinyaga County, and I'm for the second petitioner.
May it please you, my lords, my lady, Njeri Maina for the third petitioner. I appear with Andrew Muge and Christopher Wainaina.
Your Lordship, Your Ladyship, my name is Ogada. I appear alongside my brother, Mr. Sakimpa. We appear for the fourth to the eighth petitioners. I have also been asked to hold brief for the Law Society of Kenya, which is represented by the following councils: Mr. Kevin Mishuki, Mr. Wycliffe Oyo, Ms. Wangari Kagai. They appear online.
My Lord, the presiding judge, my Lord and my lady, if it pleases you, my name is Wamboi, Shadrach Wamboi. I appear for the 9th petitioner. I have the honor and privilege of holding brief for my senior, Mr. Dunstan Omari, Mr. Samson Nyaberi, my learned sister, Miss Wanjiko Waithera, and my learned friend and colleague, Mr. Jeff Kangeve. Thank you. For the 9th petitioner.
And Your Lordship, the presiding judge, and Your Lordship, and Your Lordship, Justice Mrima. My name is Kirago Wadhuta. Together with my learned senior, Mr. Kibe Mungai, and Mr. Peter Koira, for the 10th to 41st petitioners.
If it may please you, my lords and my lady, I'm Omanyi. I do appear for the 58th petitioner, together with Mr. Bernard Nirito.
May it please you, my ladies, my lord. My name is Ndeg Wanjiru. Alongside Mr. Boniface Nyamu, we appear for the 44th to the 49th petitioners. We are ready to take the judgment.
May it please you, my lords and my lady, Phyllis Wangoi, appearing for the 43rd petitioner, together with my fellow counsels, Omoke Murara and Sasha Wamai.
May it please your lordship and your ladyship. My name is Mosongo. I appear for the 7th interested party, Kitocha Sharia, alongside Margaret Awor.
Please, your lordship, my name is Daniel Manso. I do appear for 3rd interested party.
Ouma. For the Senate and the Speaker of the Senate, the 3rd and 4th respondents, my learned friend, Professor Tom Ojenda, appears with Mr. Mokele Moni and Ms. Thanji. Dr. Thionkolu has already introduced himself, and I will not repeat that. For the 9th respondent, Mr. Michael Moshemi, and Ms. Gathira is holding brief for Mr. Kamodo for the 10th respondents. Ms. Joy Anami and Hassan Noor are instructed by the 16th respondent, IEBC. Those are the appearances. Sorry, I would like to amend the representation of the Speaker of the National Assembly to include Mr. Sore, S-O-R-E-H, Sore. Those are the appearances. One.
Judgment. My name is Harrison Kinyanjui. With your very kind indulgence, I do appear for a petitioner in petition E586 of 2024. And my lord, my lady, we filed an application in the Court of Appeal to arrest the delivery of this judgment. This was after the 4th of June. The same petition was not heard when you had directed and ordered it be heard on this, on the 7th of June, 7th of May. You had ordered, directed it be heard on the 4th. On that 4th, it was not even listed for a mention. It was listed for a hearing. Because your initial direction was that that petition should be heard as a standalone petition, so that then the decision that will be made in the consolidated petition, together with that, would now be the judgment of the court, because the Honorable Chief Justice had appointed your lordships and my lady as the bench in that petition and as a bench in this petition. Now, when on the 4th of June, the said hearing aborted, we filed an urgent application before the Court of Appeal. CO application number 291, E291 of 2026. I also wrote an email letter to the Chief Justice as the head of the judiciary to bring into her attention the precipitate injury and ruinous violation of the petitioner's right to be heard before you render yourselves in this petition. Accordingly, the Court of Appeal certified that application as urgent. This morning, I served on everyone, including all the parties that are before you now. That application relates to the Court of Appeal's jurisdiction under Article 165(3), and therefore, in deference to the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest the delivery of a judgment, so that then a judgment can be rendered that is encompassing that petition and the consolidated petitions. I had, in deference to Section 20, subsection 1H of the High Court Administration and Organization Act, informed the Deputy Registrar of this court that application pertains to the arrest of the delivery of your judgment. And the Honorable Deputy Registrar then alerted me, asked me if I had communicated that to everybody, and I did. And therefore, in deference to the equivalent of the least pendants rule, that application being alive before the Court of Appeal, that this Honorable Court then defers the delivery of the judgment. My lords, as I close, my lady, the right to be heard, being enshrined in Article 25C of the Constitution, it is non-abrogable. It cannot be abridged. But if this judgment is rendered, and peradventure, you find, as indeed you would find, that in petition E586 of 2024, that there was no impeachment, the constitutional threshold was never met, and then you grant that petition, you nullify the impeachment, you render the decision according to the pleas of the petitioner in the amended petition, then your lordships, and my lady, if peradventure you were to dismiss the petitions, herein it would be very embarrassing. So I suggest, in deference to that constitutional authority of the Court of Appeal, that you defer the rendering of this judgment. We can be heard tomorrow, because we filed our submissions ready for the 4th of June in that E586. And then the ship can sail. You can render a judgment, whether to dismiss or grant. Thank you.
Do you have an order from the Court of Appeal on this issue?
The Court of Appeal, as a matter of judicial notice, my learned friends will be aware, has the way of disposing of any matter.
I don't think we are ready for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business.
You have answered me. You have answered me.
May I finish,
Judge? You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond, just for good order? My lords and my lady, we do not in the list, I do not in the list, want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June 2026. And so that my learned friends can respond. On the 7th of May, before you, learned Senior Counsel Professor Rigathi Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinanjui relates to a file which is not before us here. And we have not taken any record in this particular, but for the purpose of transparency,
It will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my Lord, I associate myself with the submissions made by senior counsel. The fact that that file is not before you, my Lord, cannot form the basis upon which this judgment can be deferred. And most important, my Lord, counsel having not given sufficient reasons, my Lord, for adjournment, my Lord, or arresting the judgment, my Lord, I think the legitimate expectations of the 4th to the 49th petitioners, my Lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my Lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ngoya. Yes.
Thank you. My Lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my Lord, you could deliver judgment as it has been agreed before. Thank you, my Lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all.
My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Ngoya, and in the absence of a clear order, and in respect of our legitimate expectations to deliver the judgment, we then oppose the application. Thank you.
Thank you.
If it may please you, my lords and my lady, I remember actually as the 58th petitioner, I remember when my petition came for consolidation, we were together with my senior, Mr. Kinyanjui, and he opted not to have his petition consolidated in this petition. So he has his day in court. The court can give directions in his petition. And there are also other petitioners who are not also consolidated in this matter. So for this, I will fully associate with the submissions that have been given by.
Thank you.
My lords and my lady, if it pleases you, speaking on behalf of the 9th petitioner, I will wish to fully associate myself with the submissions made by my senior and my teacher, senior counsel.
Deconsolidated these E586 of 2024 from the consolidated petitions. That is a decision of the court, not my decision. Shouldn't the petitioner have abided by that decision? Yes, he did, and yes, he has. The 7th of May, everybody here was present when that decision was made to hear that petition. I'm answering, my lord, I'm answering because they say that this is something that I've just come up with to scuttle the hearing. It's my rejoinder, with tremendous respect, my lord. And I'm not going to take too long. I'm alive to the fact that this court is on a constitutional duty. My lord, the date for hearing was fixed in the presence of my friends. I served that application from the Court of Appeal in deference to the Court of Appeal's directions. And we cannot sit here and pretend, as legal practitioners, we do not know the practice of the Court of Appeal. The Court of Appeal is seized of these proceedings. And this court is subordinate to the Court of Appeal. And I'm answering that issue as to no reason has been preferred to defer this judgment. The Court of Appeal being seized of those proceedings, which everybody here is fully aware. My friend has said, yes, he has been served. Everybody has been served. So we ought to give deference to that constitutional issue. The other issue raised is that, Your Lordship, there's nothing peculiar. There's nothing out of the ordinary from these consolidated petitions. Lanark Council, really, having looked at my petition, never having answered in that petition. Mutomi Thiankolu never filed a single sheet of paper in that petition. And he's appearing for the 10th respondent. Your Lordship, he cannot be heard to say that he has absolutely no reason to see what is peculiar. Your Lordships and my lady, you saw the peculiarity of that petition. You saw, and I'm not going to go into those grounds, Your Lordship, I'm not going to go. So that, Your Lordship, the petitioner wants to be heard on merit because Article 25C says he should be heard and given that right to a fair trial. As I close, none of my learned friends here, when that petition comes up for hearing, should they ever remove from their pocket the res judicata card. None of you. My Lord, I say so because they are happy to have the judgment today. And I'm going to demonstrate there was no lawful impeachment. Constitutional threshold was never met, and I'm not delving into that. So none of them, my Lord, none of them, no, Prof, please don't point a finger at me. None of them should be heard to say that my client's petition is res judicata. So that your Lordship,
Mr. Kinanjui,
yes,
we have given you enough time.
Yes, this is my last remark. This is my last remark. Since the Honorable the DR received these formal communications and was brought to the attention of this honorable court, I very believe this honorable court should have deferred to the Court of Appeal. And I said, we're not adjourning indefinitely. It's not open-ended. Even give me this afternoon, we'll be heard, and then you can render your judgment tomorrow. Thank you for hearing me.
Mr. Kinyanjui, this is the brief ruling on this matter. First of all, we want to note for record that the matter you are referring to is not before this court, either by way of a mention or a hearing or a judgment. Indeed, it is not before us, and we are not able to take notes on that matter. Secondly, because many people here may not know where you are coming from, you yourself sought to be deconsolidated in that matter. And we gave you the orders the way you wanted them. You took yourself away from these petitions. We have made a decision on that. You will not miss. Recited that matter. If they wanted to stop us, we would drop our pens. Give us a court order from the Court of Appeal, then we'll drop our pen. We don't have anything like that. Lastly, we gave directions the last time we were having this matter. We said that your matter will be mentioned after today's ruling. And for record, and this is the last comment we're making on this issue, your matter is coming for a mention on 18th of June, 2026. Parties before the court, are you ready to proceed?
Thank you very much, Your Lordship.
I take it that parties are now ready to take judgment in the constitutional petition number E65 of 2024, consolidated with Nairobi petition number E550 of 2024, Nairobi petition number E570 of 2024, Nairobi petition number E572 of 2024, Kerugoya petition number E013 of 2024, Kerugoya petition number E014 of 2024, Kerugoya petition number E015 of 2024, Nairobi petition number E522 of 2024, Nairobi petition E506 of 2024, Nairobi petition E509 of 2024, Nairobi petition number E525 of 2024, Nairobi petition number E528 of 2024, Nairobi petition number E537 of 2024, Nairobi petition number E541 of 2024, E567 of 2024, E576 of 2024, E586 of 2024, and E598 of 2024 between Honorable His Excellency Rigathi Gachagua Njuguna, Peter Kimani Kioira, Alice Wamuhu Mbugwa, Mwangi Anyeki Mbugwa Wamumbi, Kigo Kahari, Priscilla Wambui Gitari, Muchiri Ngatia, Maria Njeri, Eric Warui Mwaniki, Brian Hunja, Sarah Hubi, Margaret Wanjira, Samuel Njenga, Hebron Gakuru, Samuel Ngari, I accept, Council, that the parties are known. We can move ahead, and others versus the respondents. Speaker of National Assembly of Kenya, Speaker Senate of Kenya, Honorable Attorney General, and several others. This is the judgment.
For the sake of clarity, I believe the lead file in terms of the direction that this Honorable Court gave is E565.
Yes.
That is not quite what I heard.
Yeah, that is the lead file.
That is the position.
Yes.
Thank you.
This is the judgment. We have a $350 page judgment, and we will try as much as possible to read it. Introduction and background. In the general election of 9th of August 2022, the first petitioner, hereinafter referred to as His Excellency Gachagua, was elected as the Deputy President of the Republic of Kenya alongside His Excellency William Ruto, whom we refer to as President. Their election was upheld by the Supreme Court, paving the way for their swearing in on 13th of September 2022. beginning what was expected to be a full constitutional term under Article 145, Sub-Article 1, and Article 148, Sub-Article 6. That expectation, however, was cut short following the successful impeachment proceedings against His Excellency Gachagua. The process leading to his removal commenced on 1st of October 2024, when Honorable Mwengi Mutuse, the 9th respondent and Member of Parliament for Kibwezi West constituency, we shall refer to him as Hon Mutuse, introduced an impeachment motion pursuant to Article 145 and Article 150 of the Constitution. The motion hereafter The motion, referred to as impeachment motion, cited multiple grounds, including allegations of gross violation of the Constitution, incitement, and undermining government policy. The 11 grounds were as follows.